Good afternoon, everyone. So my name's Adam, and welcome to our webinar, Navigating Termination in Challenging Times, which they are. Thank you for joining us today. Look, just letting you know that we will get started in a couple of minutes. Please sit tight while we wait for everyone to enter the session, and we'll get the show on the road. Alrighty, looks like we've had the last few stragglers come in, and so everyone has joined, and we can make a start. Look, guys, if you missed the beginning, hello, my name is Adam Aliagage, and welcome to our webinar, Navigating Termination in Challenging Times, presented by Citation Group. Look, before we dive into the presentation, I just want to cover off some general housekeeping rules. We do a few of these webinars, and there's a lot of people that have questions throughout it. If you do, please use the Q&A feature at the bottom of your screen. We'll try and answer as many as we can at the end of the presentation. You don't need to wait till the end or anything. Just type in as it comes along. However, as well, if we do not get through to your question during the webinar, we will come back to you after. Also, yes, look, the webinar is recorded and you'll be sent a recording link after this session. Now, we have quite a few people online with us today, so I'm guessing you've joined us to learn more about termination and whether it's the right path for your business. Australian businesses are under increasing pressure, which we do know, especially in the current economic climate, driving many to consider redundancies as a cost of saving measures. However, termination decisions can expose your business to significant legal and reputational risk without the right approach. So, look, hopefully by the time we finish this session today, you'll have some useful takeaways on navigating the complexities of termination and redundancies. And look, by way of introduction, this is Olivia Perry. So I've had the pleasure of working with Olivia for around about the last 5 years. She is one of the advisory team leaders. She's one of the go-to girls that anything to do around termination, disciplinary actions, and so forth. She knows her stuff inside and out. My name is Adam Aliagage, as I said. So I'm a senior BDM here at Citation Group. I've been with the company for well over 8 years, knowing the fact what we can do for businesses, the reason why I've stayed here so long, and hopefully you'll see today some of the benefits of the advisory team that we have. So as you guys can see, this is Citation Group here. Citation Legal is where we started, so around about 30 years ago, so workplace law and migration services. Then we've got Citation Certification. It's one of the newer parts of the business, but we are now the second biggest certification company in the country. Enable HR, which is our software program. And then we have Citation HR and Citation Safety here, which is our outsourced HR and work health and safety solution for businesses. And Olivia, if you can just go to the next screen, please. Which brings us to Citation HR, and as it says, they're expert HR services for all businesses. The way that I like to look at it, as I said, I've been here for around about 8 years, is basically you have Fair Work and you've got Safe Work. They're the two regulators. For HR, it's obviously Fair Work, and it's our job to sit there and make you compliant, helping you with your employee management, and I guess staying, as I said, compliant. And how do we do that? So there's a few things that we need to do. First of all is that second part there, which is an HR compliance audit. That's for us to review your contracts, your policies, and your procedures. And you'll actually hear Olivia talk about this throughout the presentation about how important policies are to the business and having the right ones, especially when it comes to termination. You've got a 24 hours a day, 7 days a week telephone advice line with the likes of Olivia, our team there to discuss matters around your HR concerns, whether it is termination, whether it's bullying, harassment, whether it's awards. Look, it's basically a fully qualified HR professional on the end of that line for you to engage with around concerns or issues that you might not be able to handle yourselves. HR software that is there to manage your entire employee life cycle from your pre-employment to employee management all the way up to termination. And actually, what you'll hear Olivia talk about as well today is about record keeping, and that is crucial, right? And that's what the system helps do. The library of resources is built in there for letters, forms, contracts, policies, and so forth to support the business and at the same time automatically update, meaning that you never have to really worry about thinking about, oh, what changes in legislation happened? Do I need to update it? We're going to do it for you. The CTC, our Compliance Training Center, crucial for businesses now since Secure Jobs and Better Pay came in. Olivia, correct me if I'm wrong, but it is now yearly that businesses need to be doing harassment training. So harassment, sexual harassment, and so forth. That's been built into the system along with another 32 modules as well. So that's all there. HR on demand, which is the next screen, which we can click on in a second, and we'll get to that. But the advice promise, that is basically protecting businesses against employment practice liability. So we are talking about termination today. And look, the advice promise is there, basically showing that we're very confident in the advice that we give. We're there to show that if you do want to terminate someone, we're going to let you know what the risk is, or we're going to come up with a plan on how to terminate. If they then decide to go to Fair Work and lodge an unfair dismissal claim, we will actually represent you in court with no additional legal fees or excess. And if there is a settlement or payment that needs to be paid out, we actually pay that out as an uncapped amount. And from memory, I think it's been over 2 years since any successful claim has been brought against the business. So we are very confident in what we do. And then just on the HR demand, this is a new service. Look, it's been brought into play based off some feedback that we've had from clients and something that we believe, should just be there for you. Basically, what it's all about is having someone come in actually face to face. It's not just the advice, whether it's via Teams, depending on where you're located, but it could be a crisis service. So something around a disciplinary meeting where you actually want us sitting in on the meeting, not just advising on what to do. That's what this is about. Whether it's a health check, I think more around the training and crisis services is where most businesses, from my experience and the clients that I brought on, would use it. So, helping training around human resources management, workplace relations, respect at work, which is part of the training in the CTC as well, and then work health and safety. So that's a new part of the service as well, guys. Rightio. So that is actually it from me, luckily. And I'm going to pass on to Olivia from here. As I said, a wealth of experience, been working together for quite a few years. So thank you so much for joining us, Liv. Really appreciate it. And I'll hand over to you until I need to interrupt again.
Thank you so much. So just jumping into a bit of what we're going to be talking about today. Obviously, terminations is a big part of that, but mainly looking at obviously the concerns that we have for Fair Work claims in that process. So specifically the two main ones being unfair dismissal and your general protection claims. We'll then be going into a bit more of the process and procedural fairness elements so that we can make sure we're mitigating those claims. And then all the different types of terminations that we do have in a business. So termination in minimum employment period, or that MEP, termination for performance and serious misconduct. And then just to finish off, we'll go through a few extra tips and tricks in regards to that performance management as well as termination process as well. So there's a few reasons why there might be a cessation of employment. I've mentioned a couple already in that agenda, but obviously resignation may be one of them. Obviously, generally one of more the easy cessations of employment, you just have an acceptance letter. But we'll obviously be going into performance concerns, serious misconduct in general. But as well, on top of that, there is redundancy as well as termination in minimum employment period. So there's a few multiple reasons why you may need to consider termination for an individual employee. So we're going to be looking at a few of the definitions within the Fair Work Act 2009. When I'm mentioning the Fair Work Act, there is only one, that 2009 one. So keeping in mind that will be the one that I'm referencing from here on out. But looking at a few of the clauses, you can see here we've referenced section 386 for those who love the legislation part of it like we do. And basically that definition is a person's employment has been terminated at the employer's initiative. So you can see with that employer's initiative for dismissed, it's quite different in comparison to someone who has resigned. So that meaning of dismissed really does just sit more with your performance, termination in minimum employment period, or serious misconduct termination. And the really important question here to ask is, when someone's being dismissed, what does that actually mean? That definition obviously looks at someone being terminated, but it can also mean that a person may have felt forced to resign in that process as well. So something to be careful of when it comes to resignation is it can actually fall in that meaning of dismissed, and that can be for multiple reasons, of course, in the conduct of the employee, and they may have just felt forced in some way to be outed of the business. So again, something to be really mindful of, and obviously in all these processes, give us a call and we can obviously run through all the scenarios, of course, with you as well. A dismissal does not include things like demotion, so keeping that in mind. Obviously remuneration and a reduction of that can mean something different, and as well as redundancy, again, not a form of that demotion period as well. The end of a fixed term or fixed term agreement is not a dismissal also. That's simply just an end of a contract period. And any kind of specified term training arrangement can obviously be that end date or that expiry date, does not mean a dismissal as well. So moving into more of our Fair Work claims, I've got a bit of a mix of them here. Obviously, all of these come under that termination of employment banner. As we've kind of mentioned, unfair dismissal, it's one that everyone's very much aware of and one of our main ones. And we'll go into a bit more of the definition there, but realistically, the wording you're always looking at for unfair dismissal is that harsh, unjust, or unreasonable. We'll obviously talk more about that shortly. Unlawful termination. So again, we can talk more about it, but generally sort of temporary absence from the business can be one of those Fair Work remedies that come forward. Adverse action is another one that, generally speaking, people aren't very aware of, but it's a protected attribute due to a workplace right. And we'll go into a few more of those workplace rights, but that can be an option or remedy for an employee as you're going through that Fair Work process. Another one is those general protection claims. It's quite a convoluted one, so we will go into a lot more detail with that, but generally can be things like coercion, discrimination, undue influence. There's a number of protected attributes under that banner. So moving now on to unfair dismissal as promised. So looking at section 385 for that Fair Work Act. When it comes down to unfair dismissal, there's a few elements that need to be satisfied for unfair dismissal to be taken. So firstly, looking at that definition of dismissed, as we discussed. So firstly, the person has to actually be dismissed from the company. Again, making sure there's also that element where if someone resigns, that can also fall under that banner. The dismissal then also needs to be harsh, unjust, or unreasonable. So always looking at those three words, and there are definitions linked to those words as well that we'll go through. The dismissal also needs to be not consistent with the Small Business Fair Dismissal Code. So we're going to go through a little bit more in detail in terms of jurisdictional objections, which fall under that. But when it comes to a small business, basically we're looking at anyone who's under 15 employees in total. So keeping that in mind when you're looking at a small business, always thinking of that number 15 or less.
And I get this quite a lot, Liv. Sorry to jump in actually here, but with the 15 or less, with I guess an unfair dismissal claim or something like bullying harassment, does that still include underneath, I guess, employment practice liability claim if they were bullied, even if it's under 15, or is it just unfair dismissals? Sorry, it's just because it's here. I thought it was perfect time to ask. I get it a lot.
Yeah, bullying can be an interesting one, and yeah, it really is just mainly for that unfair dismissal part. And we'll keep talking about that Small Business Fair Dismissal Code because it comes a lot into action when we're looking at minimum employment period, as well as redundancy. Those are mainly where the elements change if you're a small business. But otherwise, yeah, unfair dismissal is a really big one with that because of that contingency with minimum employment period, basically in probation.
Thank you.
Thank you. And just that last one, looping back for unfair dismissal. So the dismissal was not a case of genuine redundancy. So that is also one of those larger protected options for unfair dismissal, that it isn't a genuine redundancy in that process. So with that eligibility for an unfair dismissal claim, in order for an employee to be eligible, they needed to have completed a minimum employment period. So again, looping back to that 15 or less, if you are 15 or less, your minimum employment period is 12 months for an employer. If you are more than that, so on the higher end of the business scale, your period of minimum employment is 6 months. So that's one of those big differing options when you are a small business or a larger business. When it comes to eligibility as well, they do need to be covered by the Fair Work Act definition. Most employees are covered, I will say, but mainly just looking at that difference between independent contractors and employees. So they do need to at least meet a definition of being an employee. With that, of course, as well, casuals are generally remitted from unfair dismissal claims. In saying that, you really do need to make sure with your casual that they are a true casual, and that's where calling our line and obviously having discussion around their hours and their days and all those kind of parameters will help in understanding whether they're actually a claim risk for an unfair dismissal claim. Obviously, in a dismissal, there's definitely valid reasons why someone can be dismissed. Obviously, employers can terminate employees for lots of reasons, whether it be poor performance, misconduct, genuine redundancy, or even just general operational reasons. So just because you've dismissed someone doesn't always mean there's going to be an unfair dismissal claim. We're really obviously just going through the risks at this stage for those and how to make sure that we're avoiding getting into that unfair dismissal area. When it comes to prohibited grounds for dismissal, which sort of loops in with your general protections elements as well, but any dismissals that are based on discriminatory grounds, of course, such as race, gender, disability, religion, that involve that workplace rights, are obviously considered unfair and prohibited under most adverse actions and claims within the Fair Work Act. We're going to talk about this a lot more in terms of procedural fairness, but when it comes to that harsh, unjust, or unreasonable element, a lot of parts where people will tend to fall through the cracks of that is procedural fairness. So making sure that you're expected to follow that really fair and transparent procedure when you're dismissing an employee is really crucial. And we'll, again, go through the elements of that, but things such as providing notice, conducting discussions, allowing the employee to respond to all the allegations, and whether that be performance concerns or conduct, is really crucial to that unjust or unreasonable section. So when it comes to the administrative body, obviously we're looking at the Fair Work Commission for all of these claims, and they'll be responsible for handling unfair dismissal claims. Again, obviously, if we get to this stage, I'd definitely be giving us a call and working through that process as you get through the conciliation process. But obviously, employees who believe that they've been unfairly dismissed can file a Fair Work claim. They generally use a form through that process, and they have 21 days to do that from the date of dismissal. So keeping that in mind as one of the options against unfair dismissal, that 21-day period essentially is how long they have to put forward that claim to the Fair Work Commission. I'm going to go through a few of the remedies a little bit later again, but most of the time the remedies will be things of some sort of compensation or payment for lost wages, but it can also include things like reinstatement of the employee back into the business, or even different documents that they may require, such as a statement of service, whatever it may be, and that'll obviously be negotiated in any of those periods after a claim. When it comes as well to unfair dismissal, you do have to be quite careful in terms of your burden of proof. As an employer, you actually have a higher burden of proof and that threshold to prove as to why the unfair dismissal wasn't harsh or unjust or unreasonable. So within that proving that it was unfair, obviously it means as an employer, you really need to demonstrate really valid and justifiable reasons for that dismissal. And we'll go through a few different elements of what that may be, but, you know, obviously going backwards from that termination process and looking at unfair dismissal as your end game, you really need to make sure that you're keeping records and documents and having really valid and justifiable reasons for all of those dismissals. And obviously, in more complex cases, really making sure that all of those records are really kept really succinctly as well. So move now to general protections. I'm still going to loop in a lot of the rest of the conversations around unfair dismissal as well as general protections, especially when we get into the tips and tricks, just because there's so much, so much to it. So don't feel like we're not going to touch base on unfair dismissals again. But looking at general protections, so it can be quite confusing when it comes to these, but essentially all employees under that employee definition, including casuals, as well as those who are in minimum employment period as well, have this access to general protections. So it's a really broad range, which obviously adds to that risk element for this claim as well. So when it comes to general protections, they're basically a set of provisions that protect the workplace rights of an employee. So as a really good example of that, and one that we see quite often come up, an employee may be unwell or sick, whatever it may be, and have a period of time off. If there's then that correlation that the employee has been terminated because they've taken that time off, especially without undue process or a just process, they may have that claim to a general protections, considering the fact that they have, generally speaking, national employment standards and access to that leave or personal leave, whatever it may be. So that's just one aspect of what can be an option. There are quite a big banner or range of banners under this general protections, but really think of it as basically what are your workplace or your employee rights. And if it feels as though that workplace right has been taken away in the termination, or there's a correlation that there's that termination because of that, that's where potentially this banner can fall under. So obviously these provisions really aim to ensure that individuals aren't subjected to discrimination, unlawful conduct, adverse treatment, again, the list sort of goes on. When it comes to, again, sort of connecting it to unfair dismissal, the 21 days, there isn't that element for general protections. So there is a little bit more of a gauge that they can actually make these claims on. And when it comes to going through the process, very similar, they'll take action through the Fair Work Commission, put through forms, and obviously you'll go through that process through the Fair Work Commission as per normal as well. So when it comes to the Fair Work Act, it really links quite a lot with this general protections, and really protections in terms of that individual right to join a union or not join a union. And this can be another big one that comes up quite often. So if an employer decides in some form to take adverse against an employee based on their union membership or non-membership, or even claims and complaints through that union membership, I just want to bring this up as sort of a larger one because it can happen quite often, and it's something that's quite a protected right under this section too. Something to be aware of if you are a company who has unions or union protections. This can be something that happens quite often as well. So when we're looking at discrimination, this one can be a little bit one that's slightly more obvious, but when it comes to obviously direct or indirect discrimination that employers can have, obviously employers cannot discriminate an employee based on their race, color, sexual orientation, whatever it may be. So really making sure that when you're looking at that process, you're really making decisions that are justifiable, have records behind them, have evidence behind them, all those sort of things that we're going to talk through, so that you're really not finding that correlation between any form of discrimination for the employee and that termination that we're looking at. So these are just a few examples of general protections. Again, the list can kind of go on a little bit, such as things like protection from misrepresentation, complaints and enforcement. That there are a few protected attributes there. But what I always try to say with general protections, if you feel as though this termination has some form of correlation to something you would feel is unfair or or unjust or, quite harsh in a process, that's when you may want to have a bit of a red flag in the back of your head of, okay, look, let's make sure we're really looking at our evidence and making a justifiable reason for this termination. Much like your unfair dismissal, similar process of that reverse onus of proof. So in cases where an employee alleges a breach of this general protections, that burden of proof shifts to the employer, which means you are then required to have that demonstration of why it is not adverse action or discrimination. So it's important to note these that obviously there's a broad range of these, so that burden of proof can be quite difficult in some circumstances to go against. When we're looking at remedies for general protections too, in comparison to your unfair dismissal claim, which has a cap in terms of how many weeks you are able to claim, your general protections is actually uncapped at that amount. So realistically, that monetary value we're unsure of on the basis of that. So it can be a reason that this general protections is a really high risk element for a business because of, firstly, obviously how broad it is, but then secondly, how broad that monetary value or compensation value can be. So something to really make sure you're keeping in the back of your mind through any termination process. So who can claim? Just a really quick one. I won't go too much into this one, but basically when we're looking at the award or non-award employee, we've also got that high income threshold level, casual employees, and then you can see here that fixed term or seasonal apprentice. So I have made a note here, unless employment has been terminated early, of course, obviously at that agreement point or the end point, it doesn't quite fit that criteria of a dismissal. Just to sort of loop back, apologies, I didn't mention the high income threshold, but that high income threshold, it does change every 1st July. So at this stage, it is sitting around the 175,000 mark, as you can see. So generally speaking, when it comes to unfair dismissal claims, in comparison to here with the general protection claims, if you are in that high income threshold, you are ineligible for unfair dismissal, but however, eligible for general protections. So as promised, some jurisdictional objections. This is more for your unfair dismissal claims, I will mention. So obviously if the employee is in their minimum employment period, which we'll go through how to terminate in those processes shortly. If the application is out of time, again, looping back to that 21 days, individual wasn't an employee, your independent contractors as an example. And then we're looking at that dismissal and genuine redundancy as course as well. And as mentioned, the high income threshold or potentially not covered by a modern award or enterprise agreement. So these are a few elements where if you do have a form come through from the Fair Work Commission for an unfair dismissal, these are some objections you could have come back to the Fair Work Commission in regards to why it does not meet that criteria of unfair dismissal. I think we might have a bit of a break for my voice now.
Yeah, it's my time to shine. No, thanks, Olivia. Look, really informative. Everything you brought up there is a lot of the questions that I receive from clients that we have. So hopefully that this presentation so far has helped people. However, some of the things that might have been raised might have led to additional questions. And as part of this webinar, if you can look to the right of the screen, you will see the QR code. If you scan that, we are more than happy to arrange a complimentary call, whether it's today. It says today there. Look, we understand people are busy. If it's tomorrow or by the end of the week, that's absolutely no issues. Whether it's around something that you've heard today or whether it's around something just that hasn't been, something that isn't around termination, it doesn't have to be that, guys. So look, we understand that's the topic and the reason why majority of you are probably here today. However, when it comes to the call, anything to do with an HR related matter, we'd be happy to help. And that is a complimentary call. So look, I'm going to just pause this for 30 seconds, just so that gives people time to scan the QR code. And then we will jump back into it after that. So I'm just going to count down from now, guys. 5, 4, 3, 2, 1. All right. Look, we're going to show it again at the end of the presentation anyway. So look, hopefully you got it then. If you didn't, we'll get it back on. But I'm going to pass back to Olivia now. But as I said, guys, it doesn't have to be about the topic today. Any HR related matter, please give us a buzz. Back to you, Olivia.
Thank you very much. So second half, we're going to be looking at process. So mainly looking here at that procedural fairness part. I know I did mention in unfair dismissal, procedural fairness is probably one of those parts where we really see the cracks start to form for that unfair dismissal portion. So when we're looking at procedural fairness, we really need to make sure, again, we're kind of looking at the end first of that termination and unfair dismissal risk as an option, and then work backwards to make sure we're meeting all of that criteria. So I've put in again that harsh, unjust, and unreasonable, and what the Fair Work Commission will take into account with that. So the few options here is whether the person was notified of that reason, whether the person was given an opportunity to respond to that reason, or that capacity concern, the conduct, whatever it may be. And when you're having that opportunity to respond, you would kind of obviously mix the notification and that opportunity to respond together. And we'll go through a bit of that process in a little bit more detail, but you'd be looking at obviously making sure that they're very aware of the concerns that we're having, whether it be conduct or performance. And because of that awareness that they have, they're then able to respond in a reasonable fashion to that concern. Also, obviously, in this procedural fairness, that third dot point there, any unreasonable refusal by the employer to allow that person to have a support person. This one's quite an easy one to obviously tick off, just making sure in any kind of formal process, you're offering a support person to be present. Whether that be in the invite, making sure that you have a note of it, or even starting all conversations in those meetings with the fact of whether they would like to have a support person present, stopping the meeting if they would like to, and they don't have someone there, and even just having a bit of a tick box on some of your documents or scripts, whatever it may be, to say whether a support person was present or not, just for that record keeping. So that one's quite an easy one to tick off, but an important one nonetheless. And then obviously if the dismissal is related to unsatisfactory performance, apologies, whether the performance was warned to the employee is a really important one. And with this one, I will obviously note that when we're looking at termination in that minimum employment period, so the 6 months for large business, 12 months for small business, obviously that one is a little bit less required, especially with that unfair dismissal, not having access to it. So really with this procedural fairness one, we're really looking at those who are outside of that realm and an unfair dismissal risk. When it comes to that related to unsatisfactory performance portion, this is where we're really looking at things like performance improvement plans, invitations to employees, warnings based on conduct, really sort of justifiable and evidence-based criteria to make sure that we're really showing as to why the dismissal was basically not that constant, what I'm saying, harsh, unjust, or unreasonable.
And that's where the service also comes in really well, right? Because it's not just the advice that Olivia, like someone like Olivia gives, but then you've got the software program that not only sends the letters, but it gives you the checklist to kind of tick off, yes, we've done this, yes, we've done this, invites the letters and everything as well. So it's a really good point there to show how crucial it is to keep the recordings of everything that actually happens, right? It's one of the big things that they say the Fair Work looks at is recordings, right? It's like make sure everything is documented from start to finish.
Yeah. I'm probably going to say it 1,000 times in this webinar. Evidence and records, biggest tip if you take anything from me talking at you today. But yeah, exactly right. Obviously with this process, give us a call at any stage if you are looking at, even while you're in minimum employment period, some sort of performance or conduct concerns. Because again, even if you're in the first 3 months, it's still going to create that evidence in the future should you need it down the track. So that's where I always sort of say, look at unfair dismissal as your worst case, and you start from that point and work your way backwards to make sure you're fulfilling that criteria as early and as consistent as possible. So termination in minimum employment period, I did just want to really touch on this as one of obviously the options of the criteria cessation of employment. Again, as mentioned, typically 6 months, but generally, obviously, with that small business can be 12 months as well from that start date of employment. I will mention, because we get this question all the time, if someone moves into a new role, does that restart that minimum employment period? It does not. It's from that period of their start point, and then from then onwards, it's basically that 6 or that 12 months. Another question we do get quite often in this minimum employment period as well is, what if we list probationary period as 3 months within our contract? That's perfectly fine. It still means that that period is still 6 months or 12 months for access to unfair dismissal with those elements of that. But some companies just do prefer to have it as 3 months within that probationary period, just so you can have a touch base with the employee and see how they're going in that 3-month period, and that's completely fine. And I do obviously suggest that you still have those touch bases with a new employee, just from that HR perspective as well. Basically, obviously, I've got a few dot points here around the fact they don't have access to unfair dismissal. Won't go too much into that because we have talked about it. But I will go a bit more into that notice period and that probationary part when it comes to the formal process. So that last dot point there, basically no formal process is required for a termination of minimum employment period in comparison to that outside of minimum employment period. So it doesn't mean, I will say as a rule of thumb, that you can terminate anyone at any point within a minimum employment period. We are
That's
still
risky.
really looking.
That's a risky word.
Yeah, no promises there in terms of that. And that's why we always look at that general protections part as that really overarching, keeping in mind they have access to that still. But basically, when we're looking at minimum employment periods, have they met that satisfactory standard of their role within that period? So it really does connect to performance, obviously. And when it comes to that, again, not a guaranteed able to terminate, but there is a lot less formal process that's required in a termination of minimum employment. With that notice period as well, generally in the first few months, it'll be about a week or so, but really keeping that in mind when it comes to your specific award and award coverage, which we will go through, of course, and any kind of contractual arrangements that you may have. With the Fair Work Commission's role in a termination of minimum employment period, if there is a dispute over whether they were in that minimum employment period or from when it started, whatever it may be, we'll obviously give guidance on that, but the Fair Work Commission will also give guidance to the employee through that process too. So when we're looking at dates, it is very important that we're making sure the notice period is either finishing prior to that 6 or 12 months, because they will be looking quite succinctly at that date. We've said it a billion times, but obviously documentation and communication is very important through this process still. Even though they are in probationary period, I would really push that any sort of performance evaluation is occurring throughout as well. So you might even have just a monthly catch up with your employee. That's great on their end as well. They feel as though they're getting seen and heard through the processes of their performance. And you can really sort of mitigate any kind of little niggly bits that are going on within their performance as well. So great on both ends, and also it creating that record should we have any kind of risk come forward. So this is kind of more the tricky one, I will say, but termination outside of minimum employment period. This one we're going to focus on performance management specifically, and my next slides will look at misconduct and serious misconduct. This is one where we really focus on performance management pretty much, and another really crucial one where I think giving us a call, working through your performance improvement plans, your structure of that process is really important, and we'll be able to assist you with whether a performance process or a performance management is reasonable and justifiable as well. So to give you, I guess, a bit of an example on that, we have a few calls sometimes most days where employers are maybe wanting to performance manage someone because they're taking a few days off and utilizing their leave. That would be something where we'd maybe look at that reasonability of whether it's reasonable to performance manage that. In comparison, if someone's taking quite a lot of leave but not following their leave procedure and not following their policies and their process for that, that's where we may look at some form of performance management process, and it would be reasonable to have that conversation around procedure following rather than the fact that they're taking that leave process. I will say there's no Fair Work specific process that's mandated, but following a real fair process that we obviously sort of more mandate from a HR perspective will obviously help with that unfair dismissal risk process to say that we've given a justifiable reason and it hasn't been unjust in any way. So with that process, there's kind of three elements to that. So firstly, we normally say 24 hours notice for a formal disciplinary invite. With that invite, obviously using our cloud system will help a lot because it does all the documents for you. But with that invite, listing all the allegations, noting that they're going to be invited to a meeting, putting all your performance pieces in there is really crucial. So again, they're aware of the issue and the concern prior to the meeting. And that third one, touched on it as a really easy one, but offering support person. So just going through those again, 24 hours notice, information within the invite of the concern, and support person. And that'll be a really easy step-by-step three points to follow to make sure that we're following that procedural process that's sort of more a natural process.
I think what's important there as well when it comes to the end of that process too, it's either no further action, a warning, or termination, right? Just because you've done a performance improvement plan doesn't mean you can terminate immediately. It might mean there might be another process and so forth to go through from there, correct? To I guess work out the right decision at the end.
Yeah, exactly. And that's where that outside of minimum employment period becomes so much more complex because, one warning might not be sufficient enough to then terminate, but, we're potentially looking at 2 or 3 warnings. And it really does come down to each specific person, specific employee as well, and their concerns. Of course, there's going to have a broad spectrum of this is a large concern for the business and we are quite worried about your ongoing employment with us in comparison to someone who, has maybe dropped the ball for a couple of weeks and you can really just build up their learning and make sure they understand a process. And that's where sort of the next element of it is really that extra level of consultation and communication. So, effective communication to the employee and making sure that you're really showing that you're wanting them to perform better and you're wanting them to get better, and offering things like a buddy system or an extra training day, putting in checklists for them, really showing that you've gone above and beyond for the employee to try to get them to that satisfactory standard is really the push for this section. And providing things like regular feedback, evaluations, performance improvement plans, really open and transparent communication will obviously help with any kind of misunderstandings and eventual disputes as well.
And that's, I assume, where the not to record keep again comes down to, because if you're giving them all these options and these opportunities, but they're not doing anything about it, and so the employee is just going, yeah, whatever, who cares? You've sent all this information saying we're giving you training, we're giving you a mentor, we're doing all this, and then at the end, if you go terminate and they've done nothing with it, you can sort of sit there and go, well, you actually haven't responded to any of this, and we've given you all of this, I guess, information. Is that sort of, I guess, helps. Yeah.
Yeah, exactly. And that's where, if we are looking down the barrel of an unfair dismissal claim, we can say, well, actually,
It's
here's
been
X, Y,
three
and
months. It's
Z.
been 3 months
Yeah.
of help trying to get you through this. Yeah, cool.
Exactly. And that's exactly why that, primary goal of this section is to make sure the employees improve their performance. And as long as that's the intention and that primary goal that you're consistently thinking, you're really going to be in a strong standpoint for any kind of concerns. And in that, obviously taking into individual circumstances. And I did want to touch on that because factors such as your employee's health, any kind of mental health concerns, disabilities, whatever it may be in that terms of personal circumstances, making sure that you're taking that into consideration. As an example, you wouldn't put through a performance improvement plan for someone who's going to be on annual leave for the next 3 weeks. Obviously, they're not going to build up that performance while they're on leave. So again, it really does have to sort of filter in and flow with the individual employee, of course, as well. So this was just another little touch point on that performance management kind of process, the procedural process, really focusing on that communication and consultation, but just something I wanted to pop in for everyone to kind of look at it as a bit of a structure, making sure that you're really following that fair opportunity to respond to concerns, tick that box. Then we move on to the next box of making sure we're really focusing on that goal of performance management and that employee building up to the standard that we really want as well, so that they're not feeling misunderstood or misheard. So when we're looking at performance out of term minimum employment period, apologies, so sort of tick, tick, tick for 1, 2, and 3, and we're looking pretty smooth and good, hopefully. Next one. We've got here a couple extra points. So opportunity for improvement, again, sort of mentioned in that third one, yes. Consideration for individual circumstances, written documentation. You're probably going to hear me say that a billion times over, but making sure everything's got some sort of documentation is really crucial.
As well, the employees get it has to lot go into place for them to get terminated. So everything needs to be done right, unfortunately.
Exactly. And, we don't want to put ourselves at risk as a business. So we try
Yeah.
and do as much as possible. But yes, look, we'll move on quickly, so I'm not talking too long for everyone. Serious misconduct is our next sort of termination outside of minimum employment period. Obviously, serious misconduct can definitely occur in minimum employment period, and I would definitely just suggest having a discussion around serious misconduct with one of us if they are still in that first 6 months. Mainly because serious misconduct can have an action where you aren't required to pay your notice period. But again, a discussion to have, as you do have to go through a pretty stringent process for serious misconduct. But generally speaking, serious misconduct and that definition of it falls under quite severe concerns for the employee. So things such as fraud, violence, stealing, theft, these are some examples of that. And again, obviously, as you can imagine, that threshold for how much we need to prove that that's actually occurred, the wording is basically beyond reasonable doubt. In that lawscape, you'll hear that wording a lot, but you really need to make sure that when you're thinking about the evidence behind it, it's definitely in that level of beyond reasonable doubt. So similar sort of process, however. So the top 3 that I always say to people: 24 hours notice, support person offered, and those allegations listed in some form of letter. That will help with all of these processes. So you can kind of see the 4 here, providing that 24 hours with an invite. With that invite, apologies, we're having the allegations really listed. As a really good working example that we kind of work with when it comes to allegations listing, I tend to just suggest something like on insert date. So you're giving a relevant time frame and date. You know, X, Y, and Z, whatever the concern may be. And always linking that back to the company and how that serious misconduct has affected the company. So, which resulted in a breach of policy, which had concerns and eventually made the company lose a client, something along those lines. So showing sort of really that flow on effect of when it occurred, how it occurred, and how that action occurred for the employee, and how there was that effect on the business. And it'll give quite a lot of information to the employee to make sure that they then have that next portion that they're able to respond to that allegation. Obviously, in that process, much like performance management, of course, really conducting a thorough and impartial investigation. Obviously, that may be where potentially use some of our extra additional help with citation HR for an impartial investigation in that threshold level. And then providing an employee with an outcome. When it comes to an investigation, obviously doesn't have to be termination as an outcome. A warning may be sufficient based on the information and evidence that you have. But obviously today we're looking at terminations, so the outcome may be termination in that instance. So a few practical tips, overarching, again, evidence. making sure everything is written down. I didn't pop too much into that for you because I know we've talked through about it a lot. But a few top tips will be consider making a decision-making structure. So recommended having someone who is a deciding factor in a lot of these decisions, whether it be someone impartial or a HR, manager, managers in general, whatever it may be that's best within your business. Having a bit of a structure and process in place as a business for all of those options, misconduct, serious misconduct, performance, is really going to help. As well as it gives transparency to the employees that they can have some sort of policy and structure that they follow in a business too. Um, Obviously, isolating decision makers to make that non-bias options there, and ensure where possible they don't have any kind of special interest in the outcome. I will say, obviously, that's a little bit harder in your small businesses, but as much as possible, really trying to isolate these decision makers. And the decision maker must know all the details of why they're terminating. And obviously, in that, really assessing all the risks behind that too, to make sure that it's a real justifiable reason there.
And sorry to just interrupt, but I think that's what you guys do really well is identify what the risk is. So it's not saying, no, you can't terminate. It's here's the reasons why. The risk is going to open you up to, however, this is the process, which is what we've sort of gone through that we believe you should take to get towards that termination, understanding that a difficult employee can, what they say is a cancer in the business. And we understand you do want to terminate, but it's about following the right processes and understanding what the risk is open to the business. And that's what I think you guys from the advisory team do insanely well. Sorry to interrupt, but yeah, I was just sort of thinking that as we're going through there. But yeah, I think that's what you guys do really, really well.
Oh yeah, getting a little bit of a plug there for our team. But yeah, exactly right. Looking at those risks, and making sure they're all very justifiable, and with that, obviously, paper trail for that. With this consistency one, it's a really handy one to have, especially with that discrimination element. If you're having consistent performance management for multiple employees for different reasons or even the same reasons, it's going to be easier to show that there's that consistency and fairness element in your process if you're across the board, same in regards to maybe KPI levels or whatever it may be. Obviously, don't rush the process. You know, obviously better to get it right the first time, and don't shy away from obviously still having the proper process you need for a business, but really making sure that you're thinking back to maybe this webinar or the discussions that you're having with our team. Have I ticked all the boxes prior to a termination? Because you wouldn't want to fall down at an unfair dismissal claim simply because you didn't offer a support person. So really taking in the process as you go through. And obviously, I wanted to pop it in here, but don't forget to provide those employees with an opportunity to respond to all concerns throughout the process. It's something we see quite often that we don't get that investigation process part. So really wanted to emphasize it. So we're making sure that we're fulfilling that procedural fairness element.
And I think the dotes from what I experienced with talking to clients are one of the biggest challenges, rush the process, especially. They're like, I want them out, I want to terminate, that's it. Which I get, but as a business owner, it's about following these do's that Olivia's mentioned that does make it work out better for you in the end. But the don'ts I can appreciate for business owners are probably hard to adhere to at times. But it's definitely recommended from the right place.
Yeah, sometimes the last thing you want to think about is a support person when you've got someone who's who's making it difficult in a business. But always think about the fact that general protections has an uncapped financial amount. It might help the process feel a little bit more stringent. That is sort of my tips there. Obviously, one of my bigger tips is obviously giving us a call and having that risk process, of course, as well, and utilizing your documents as much as you can, templates, policies, and procedures. They're all really going to help the business in terms of a HR best practice, but also in terms of these risks and concerns when it comes to a termination as well.
Back to me. Thanks, Olivia. That was amazing. As I said, guys, we were going to bring this up again, so you do get another opportunity now to scan QR code to book to get a free trial call. In the meantime, as well, I have seen quite a few questions come through. We'll see how we're going for time, but we'll definitely answer a few of them. So, Olivia, get ready. I'm going to throw. I think there's about 4 or 5 that will have time for. But in the meantime, so if you're any issues with HR, whether it's termination, what we're talking about today, whether it's wanting to understand some legislation changes that might have happened, any of those type of things, please call us. The free advice line is there. Scan the QR code to your right. We're going to give you another 15 to 30 seconds to do that. In the meantime, think about record keeping. I think was one of the big takeaways from today, making sure that everything is recorded. Look, we'd love you to use our service, but at the same time, even if not, Olivia, I'm assuming emails, SharePoints, Google, those like Google Drives, those type of areas, so long as you're storing something somewhere and keeping a record of it, it's really important. Can't harp on that enough. I'm going to be quiet for the next 20 seconds, let you guys do that, and then we'll get to the questions. All right, 5, 4, 3, 2, 1. Awesome. All right, so I have got 4 questions here that I think we'll be able to answer in time. So, Olivia, are you ready? All right, let's start. So, look, question 1. So we have an employee who has been on sick leave for a very long period of time. Can you terminate employees on extended, sick leave?
Yeah, so I know I said unable to terminate people for sick leave, but there's exceptions to every rule. Generally speaking, if you've got someone who's on a really long extended period of time of sick leave and there's a concern that there's no capacity for them to return to the job or for them to be able to sustain the role, again, would go through quite a stringent process to confirm that, whether it be with the 24 hours notice and all those sort of details we went through. But you can, with a medical professional, deem someone unable to continue the role. And that's where you may look at that termination. Again, in saying that, we did discuss that there's a really high risk of general protections for that one, as well as unfair dismissal. So I'd be quite careful and stringent in the way that you're doing that process, that it's with a medical professional and you're really looking at the extended period of time as well.
Awesome. And as you can see, very detailed answer by Olivia as always, which is great. So this is recorded too. So we're going to send it to you. And also, as I said, you can reach out to us if you want any clarity around that. Question number 2, what policies should we have in place to support performance management / termination?
So there's always kind of a core 3 that I sort of say when it comes to these levels. A few are your employee handbook, a code of conduct, and also some sort of grievance or performance process. So I sort of mentioned in one of the tips and tricks, having a performance process and policy that has, please see X person for managerial concerns or performancing processes, whatever it may be. Having that in place can really help to support the process. But even then, having a specific performance improvement plan process and documentation that's really fair and for everyone really helps with that fair process portion too.
And that's something that's, sorry, on my own behalf, that's something that's done, I guess, at the beginning of when they're employed, understanding what that process is. And then if anything changes, make sure they understand it and they acknowledge the fact that they know what's going on essentially in the company. That'd be right.
Yeah, definitely. That's sort of one of our biggest things when we have clients come on. We're like, do you have policies? If no, here they all are.
And here's why you need them.
Exactly. There's multiple reasons why you need them, but it's a really good point for policies as well, especially like your employee handbook and your code of conduct. As I was going through with that allegations part, of on insert date, etc. That's where we can really link it back and say, you've breached X, Y, and Z, and that was mentioned to you and sent to you in X policy.
Yeah, you understood this and read this on this date at this time. And
yeah.
Awesome. All right, question 3. What can we do to ensure we protect company property in the instance of an aggrieved employee who has been terminated?
That's another really good policy throwaway one. You may have a policy in there or something along those lines that dictate whether it be a company car policy, mobile phone, those sort of things, especially if you're in an industry where you're using quite a lot of tools. Really important to have something, an extra document as well that lists and has a signature of the employee of what those items are that they have. It does get into quite difficult territory, of course, if the employee is holding on to those and they've already left the company. So really making sure that within that termination process, you're starting the conversation, if you are in that termination process, of that return of company property as a crucial part of that, end of cessation.
Awesome. And look, I know that you got a busy day ahead of you, and I do appreciate you taking the time, but we've got one more here. How does the company execute termination according to employment contract T&C and remaining compliant to Fair Work regulation when there are employees who do not belong to any category in the awards?
So you might have obviously employees who are award free, which can throw slightly a bit of a spanner in the works. But in saying that, I probably wouldn't detour from any of the processes that I've spoken about today. Always a good idea to still be a part of that process of the 24 hours, etc., etc. That general protections is always going to have a layer for you, most likely, even with your award-free employees, again, taking into that factor the high income threshold. But, realistically, I think still executing the termination as you would normally, firstly, that helps with the fairness aspect, but secondly, can help just in case they turn out to be award covered, as an example. In terms of employment contracts, again, you may not detour too much to that, but taking into consideration reading the contract prior to any termination, it may have different factors like a bonus or commission structure in there, a notice period, different restraints that the company has for the employee. So that's where you can obviously deviate from award free. So really looking at the type of contract and the clauses of your contract can help with that process. But realistically, treating an award-free employee much like an award-covered one can really help with that fairness, and we definitely suggest still following that process.
Amazing. Thanks everyone for attending. Look, we really appreciate it. We hope that you've also got something out of this. I certainly have as well. Hopefully make me better at my job from the knowledge that Olivia is able to provide us. Look, the QR code is there again. As I said, we got to 4 questions, but I saw around about 20 or 30 there. So look, we will endeavor to get back to you as well around the questions that have been asked. However, that QR code is there, so please use it. It is free. There's no obligation. Happy to have a chat. You might get even Olivia on the end of that line. It won't be me, that's for sure. But look, thank you again, guys. Have a great day. See you later.